Hello and welcome to this video lecture on the use of criminal law to fight match fixing, which is part of Unit 7 of our program on sports law.
I'm John, and in this video lecture, we will look at some of the provisions of substantive criminal law in India to examine whether they can be applied to instances of match fixing. The Indian Penal Code 1860 is India's general criminal statute. It defines a variety of offences and prescribes the maximum sentences that can be handed down to persons who have been found guilty of having committed those offences. Some of these offences, such as cheating and dishonestly inducing delivery of property, criminal breach of trust, criminal conspiracy, have all been argued to apply in cases of match fixing. Let us now examine them one by one. The offence of cheating is defined in section 415 of the IPC. The essential ingredients of the offence of cheating are: 1. Deceit of a person. Secondly, the person thus deceived has to be induced to A. Deliver property to another, or B. To consent that any other person shall retain some property, or C. To do or omit to do something which that person would not otherwise do, and such act or omission is likely to cause damage or harm to that person in body, mind, reputation, or person. The crucial ingredient here is that the victim had to be deceived and thus induced to do one of the acts listed in the provision. This means that at the time the victim does one of the acts listed in this provision, the accused person in question should already have been possessed of a guilty intention to fix the match. Now let's see who some of the potential victims of match fixing are. It could be a spectator who has purchased tickets to watch the game. It could be an owner of the club for whom the accused athlete plays. It could be the governing body of the sport which feels that the sport has lost some value. It could be a sponsor. It could be a broadcaster. Let's take the case of a spectator. Now, if the prosecution wants to make the charge under section 415 stick, then it has to prove that at the time the spectator purchased tickets to watch the match in question, the accused athlete was already possessed of a guilty intention to fix the match. If the accused athlete plays for a club and the victim is the owner of that club, then at the time the owner of the club paid the athlete to play in the game, the athlete should already have been possessed of a guilty intention to fix the match. This is very often not the case. Also, it is extremely difficult to prove. The offence of cheating and dishonestly inducing delivery of property is defined in section 420 of the IPC. The essential ingredients of this offence are: A. Cheating of a person. B. Dishonestly inducing that person to 1. Deliver property to any person, or 2. Make, alter, or destroy whole or any part of a valuable security or anything which is signed or sealed and capable of being converted into a valuable security. Here too, we faced with the same problem that we did in the case of the offence of cheating. At the time that the victim delivered the valuable security or destroyed the security, the accused player or accused referee or accused umpire should already have been possessed of a guilty intention to fix the match. Now, if it's the spectator who delivered the property or if the owner of the club who delivered the property, it is very often not the case that the accused player or referee or umpire was already possessed of a guilty intention to fix the match. As we have seen, it is also difficult to prove. The offence of criminal breach of trust is defined in section 405 of the IPC. The essential ingredients of the offence are: 1. A person has to be entrusted with property, and 2. That person dishonestly misappropriates that property or converts to his own use or dishonestly uses or disposes of that property in violation of any direction of law prescribing the mode in which such trust is to be discharged. In the context of match fixing, it is difficult to argue that any person was entrusted with some property. It is also difficult to argue that such property was misappropriated. To make a charge under Section 405 stick, the prosecution has to prove exactly what property was transferred to the accused player or referee or umpire and exactly how it was misappropriated. This, as we can see, is a difficult argument to make. For the offence of criminal conspiracy, which is defined in Section 120A of the Indian Penal Code, the prosecution has to prove that two or more persons agreed to do an illegal act or a legal act by illegal means. Now, the problem with this provision is that it relies on the prosecution being able to prove an offence under one of the sections that I've already discussed. In other words, you can't have a criminal conspiracy if you don't first have a crime which forms the foundation for that conspiracy. The Maharashtra Control of Organised Crime Act, or MACOCA, which is a legislation that has been written specifically to target organised crime, suffers from a similar weakness. It requires the prosecution to prove either continued unlawful activity or membership in an organised crime syndicate. Both these offences require the prosecution to first prove a crime under one of the sections that I've discussed previously. The most promising statute, and this is a view that has been shared by the Central Bureau of Investigation in its report into match fixing in the year 2000, is the Prevention of Corruption Act. The Prevention of Corruption Act is a statute that targets corruption among public servants. Under the statute, the prosecution has to prove that a bribe was offered to a public servant. And a public servant is defined as someone who performs a public duty. Now, when does an athlete qualify as a public servant? In light of the Supreme Court's decision in the Zee Telefilms case, which said that the Board of Control for Cricket in India, which is the BCCI, was amenable to writ jurisdiction under Article 256 of the Constitution of India, which is a statement that means that the BCCI has state-like features. Under these circumstances, an argument can be made that an athlete employed by the BCCI is a public servant. Now, this argument itself is a bit of a stretch. However, to argue that athletes employed by clubs or athletes employed by other sports federations are public servants as well is even more of a stretch. In this video lecture, we have seen how difficult it is to prosecute match fixing using Indian criminal law. We have seen how difficult it is to use cheating and dishonestly inducing delivery of property, and criminal breach of trust in the fight against match fixing. We have also seen how useless the provisions of criminal conspiracy and MACOCA are if the prosecution is not first able to build a case under one of these three sections. We have seen how slightly promising the Prevention of Corruption Act is. It's because of a combination of all these reasons why India has started debating the need for a specialized law to combat match fixing. In the reading material to this unit, you can read about how other countries have used their criminal law to fight match fixing. This brings us to the end of our video lecture. Thank you for watching.
In the next unit, we will learn about the role of sports governing bodies in the fight against match fixing.